Hello friends, in the series on the income tax cases, today we will discuss the case of US Technologies International Private Limited versus Commissioner of Income Tax. This case has been reported in 453 ITR at page number 644. The matter has been decided by Supreme Court and the date of the judgment is 10th April 2023. In this case, a very pertinent issue was before the Supreme Court, and that issue was that whether for the deferred payment of TDS or for the non-payment of the TDS, whether penalty under section 271C can be imposed or not. There are two parts of section 271C, subsection 1, clause A and clause B. In clause A, it is written that for non-deduction of the TDS, penalty can be levied. And in section 271C, subsection 1, clause B, penalty for non-payment or for the deferment of the TDS can also be levied, but that is only for some specific sections and not for all the TDS defaults. Meaning thereby that penalty under section 271C can be imposed for non-payment or the deferred payment of the TDS only for some specific sections like section 115 O subsection 2, proviso to section 194B, first proviso to section 194R subsection 1, proviso to section 194S subsection 1, 194BA subsection 2. Other than that, if the TDS has been deposited late or after deducting the TDS has not been deposited, you cannot impose the penalty on the assessee. The only recourse available with the department is that you can take the interest or you can go for prosecution under section 276B. The Supreme Court said that in this case, that in section 271C, the words written are penalty for non-deducting the TDS. The pay word is not there. The Supreme Court said that in penal provisions, you cannot add or subtract some words from the statute. The interpretation should be very strict. In section 201, the deduction and payment word is there. In section 276B, payment word is there. But in section 271C, only deduction word is there. So, you cannot impose the penalty under section 271C for non-payment or for late payment of the TDS. In this case, the assessee has deducted the TDS, but that TDS was deposited late. The period of default was near about 5 days to 10 months. So, the Additional Commissioner of Income Tax imposed the penalty of near about 1 crore on the assessee, equivalent to the amount of the tax which has been deposited late, which was confirmed by the CIT appeal, ITAT and the High Court. But fortunately, the Supreme Court heard the case of the assessee and went on the strict interpretation of section 271C and said that the word should be interpreted in a way as they are in the statute. The payment word cannot be installed into section 271C. So, in this case, when the appeal of the assessee was denied by CIT appeal, ITAT and the High Court, even then the Supreme Court gave relief to the assessee. In this case, the Supreme Court said that in the penal provisions, the strict interpretation should be there and new words cannot be imported into the section for deriving any interpretation. Friends, this case is very important as far as the penalty for non-payment of the TDS or for the late payment of the TDS are concerned, because if we go with the bare reading of the section, then some interpretation can be taken out that the assessee has not deposited the TDS on time, so the penalty is there. But if you go by the strict interpretation, then penalty cannot be levied on the assessee under section 271C for the late payment or for the non-payment of the TDS once it is deducted. Section 271C penalty can be levied on the assessee only for the non-deduction of the TDS and not for the non-payment of the TDS. At the end of this video, once again, I am repeating the name of the case. The name of the case is US Technologies International Private Limited versus Commissioner of Income Tax. This case has been reported in 453 ITR at page number 644. The matter has been decided by Supreme Court and the date of the judgment is 10th April 2023. Thank you, friends.